Rule 18 Pre-trial Section 1. When conducted, after the last pleading has been served and filed, it shall be the duty of the plaintiff to promptly move ex parte that the case be set for pre-trial. Section 2. Nature and purpose. The pre-trial is mandatory. The court shall consider, a. the possibility of an amicable settlement or of a submission to alternative modes of dispute resolution, b. the simplification of the issues, c. the necessity or desirability of amendments to the pleadings, d. the possibility of obtaining stipulations or admissions of facts and of documents to avoid unnecessary proof, e. the limitation of the number of witnesses, f. the advisability of a preliminary reference of issues to a commissioner, g. the propriety of rendering judgment on the pleadings, or summary judgment, or of dismissing the action should a valid ground therefore be found to exist, h. the advisability or necessity of suspending the proceedings, and I. such other matters as may aid in the prompt disposition of the action. Section 3. Notice of pre-trial. The notice of pre-trial shall be served on counsel, or on the party who has no counsel. The counsel served with such notice is charged with the duty of notifying the party represented by him. Section 4. Appearance of parties. It shall be the duty of the parties and their counsel to appear at the pre-trial. The non-appearance of a party may be excused only if a valid cause is shown therefor, or if a representative shall appear in his behalf fully authorized in writing to enter into an amicable settlement, to submit to alternative modes of dispute resolution, and to enter into stipulations or admissions of facts and of documents. Section 5. Effect of failure to appear. The failure of the plaintiff to appear when so required pursuant to the next preceding section shall be cause for dismissal of the action. The dismissal shall be with prejudice, unless otherwise ordered by the court. A similar failure on the part of the defendant shall be cause to allow the plaintiff to present his evidence ex parte and the court to render judgment on the basis thereof. Section 6. Pre-trial brief. The parties shall file with the court and serve on the adverse party, in such manner as shall ensure their receipt thereof at least 3 days before the date of the pre-trial, their respective pre-trial briefs, which shall contain, among others, a statement of their willingness to enter into amicable settlement or alternative modes of dispute resolution, indicating the desired terms thereof, b. a summary of admitted facts and proposed stipulation of facts, c. the issues to be tried or resolved, d. the documents or exhibits to be presented stating the purpose thereof, e. a manifestation of their having availed or their intention to avail themselves of discovery procedures or referral to commissioners, and f. the number and names of the witnesses, and the substance of their respective testimonies. Failure to file the pre-trial brief shall have the same effect as failure to appear at the pre-trial. Section 7. Record of pre-trial. The proceedings in the pre-trial shall be recorded. Upon the termination thereof, the court shall issue an order which shall recite in detail the matters taken up in the conference, the action taken thereon, the amendments allowed to the pleadings, and the agreements or admissions made by the parties as to any of the matters considered. Should the action proceed to trial, the order shall explicitly define and limit the issues to be tried. The contents of the order shall control the subsequent course of the action, unless modified before trial to prevent manifest injustice.